At this time, I'm going to call Melissa Saunders to come forward. Melissa is an attorney with Dunlap and Seeger, and she's going to share some thoughts and perspectives about the kind of things legally that we need to be attending to along the way. And yes, she has the great pedigree of being a daughter-in-law of Connie Saunders. So let's welcome Melissa to our congregation.
Not yet. There we go. All right. Thank you for having me. As you said, I am an attorney at Dunlap and Seeger, and I practice primarily in the areas of estate planning, probate, and guardianship and conservatorship. So this is the stuff that I work on all day, every day. So there is my PowerPoint presentation, because I didn't want to get up here and fumble with that in front of all of you, in paper form here. So we're going to go over the very basics today. So at any point in time that you have a question, please feel free to raise your hand. I find it makes it a lot more interesting for everybody if we kind of make it a little more interactive instead of everybody staring at me for the next half hour or so. When we talk to people about estate planning, we're actually talking to them about two different phases. We're not only talking about what happens when you pass away, but we also talk about what happens when you become disabled. So if you are no longer able to make decisions for yourself and manage your finances, who's going to be the person that's going to do that for you, and what do you have in place to manage those situations? So when we talk about disability, we are talking about three main documents, and we'll go into this in more detail here shortly. The first one is going to be a power of attorney, and that is for finances. So generally speaking, who's writing checks out of your checking account? Who's talking to your medical insurance company? Who's dealing with the money aspect of your life? On the flip side of that is the health care directive. Now you're going to hear this called a lot of different things out and about. You might hear health care power of attorney. You might hear living will. Those are really common names that in Minnesota have been combined into one document called a healthcare directive. So there are two parts to the healthcare directive, and I believe there's some sample copies on the back table. The first part is going to be naming the healthcare agent, and that is essentially the power of attorney part. Who is it that can talk to the doctors? Who is it that can make the decisions for you? The second part of that document then is more of the living will portion. And you'll see a lot of different examples of this form. There's not a right or wrong form to do this on. But that is where you put your wishes about those end-of-life decisions. Where do you want medical care? What facility would you want to be in if it came to that? Do you want to be on a ventilator? What do you want for burial? Do you want cremation? So those are all things that are answered in the living will portion of a healthcare directive. The last thing that we're talking about is a revocable trust. And when I say trust, typically I'm talking about revocable trusts today. I'm not going to get into really the irrevocable trusts. Those are a whole different ballgame, and we could be here all day if we wanted to cover some of those stuff on irrevocable trusts. But revocable trusts are a document that not only dictate what happens to your assets when you pass away, but also names a trustee to take over if you, in the case where you were to become disabled. So that is also not only a disability document as well, and we'll talk further about that in a bit. When it comes to the death side of our estate plan, there's a lot of different ways that assets can pass. One of the first ways that assets pass are via beneficiary designation. So if you think about when you filled out your 401k or IRA paperwork, when you took out that life insurance policy, one of the first things on that form is going to be, who is your beneficiary? The second question, who's your contingent beneficiary? That's the one a lot of people think, ooh, what did I put there? So it's very important to make sure that's in line with the rest of your estate plan, because those contracts are going to control those assets if they are in place. Next, and the most common document that people are familiar with, is the will. What I find is that a lot of people don't realize that a will, in order to be effective, has to go through the probate process. You don't avoid probate just because you have a will. So a will handles probate assets, so those items in your name alone when you pass away, and it has to go through the court system to have your, what we call a personal representative in Minnesota, well, you're probably familiar with the term executor as well, to get appointed to handle the assets. So that is a will. A lot of times people will do something called the Revocable Trust, in which we actually transfer assets to that trust in order to avoid the probate process. So we'll talk in detail about all of these as we go along, but that's kind of a brief overview of what we're talking about. So first we're going to talk in detail about the power of attorney. In Minnesota, we have a statutory short form power of attorney that we do for most everyone. And the reason for this is because there are certain protections that using this form allows. Financial institutions have to recognize powers of attorney if they are doing business in the state of Minnesota. They may give you a hard time, and if that results in damages, they're liable for those damages. And that's what using that statutory power of attorney gives us, is that ability to say, hey, you have to presume that this is valid. That presumption of validity is good and bad, right? They're not going to be liable if somebody, say, misused it if it's valid on its face. Now, if they have actual knowledge that it's invalid for some reason, if someone gave them a revocation or any other reason they might have to know that there's something wrong with that, otherwise it's presumed to be valid, which is what we really do want. We can't have the banks aren't going to be responsible for policing everybody, but we do get calls once in a while, and so does the county, that if they suspect that there's something wrong that's not going quite right, and then that'll be looked into. Typically, when we're doing powers of attorney, we want those to be what's called a durable power of attorney, which means that it is still going to be valid if you become incapacitated. Really, that's typically our goal. During your lifetime, if you're able and want to manage those affairs, then you'll be the one doing that. But once you no longer are able to, that's when we want somebody to step in and use that power of attorney. So that's what the word durable means. It's the rare case where we would do one that wasn't durable. I've done it for a few people who have gone on mission trips or military where they know they're going to be gone for a finite period of time, and we don't want it to last forever. Then we also would put maybe an expiration date on it. But typically it's going to be durable with no expiration, because that's the goal when we're doing it for estate planning purposes. You can name a number of attorney in fact on the form and in different capacities. So first you're going to name a primary attorney in fact, and that could be one or two or really as many people as you want, but I don't really recommend that you go much beyond two, because at that point a committee doesn't tend to be able to get a whole lot of decision making accomplished. So I don't recommend more than two, but you can do it. In that case, you then have to make a decision. Either you use an or an and, meaning they can either act independently or they have to act jointly. The problem that we're seeing with joint is some practical problems. While it's a great idea, some of the banks are not accepting or will not open an account. Not that they won't accept it. They will not open an account with an and, because they say that they cannot police having two signatures on every check. It's just a practicality standpoint. So some banks just say, sorry, you have to do your business elsewhere because we can't handle that type of account. Also, it does require two signatures on every check. So there is some practical difficulty in having it jointly, but it's not that we don't do it, but it's something to give a lot of thought to before you make that decision. You can also name successors, and we highly recommend that. Obviously, a lot of times when between spouses, we'll have, a spouse as the primary attorney in fact, but then we're going to name a child or children as a secondary and even a third backup, so that if something were to happen, that we have other people to step in to take over. Again, you can do those jointly, independently, however you want. So. Gifting. You probably all have seen in the newspaper over the last few years that there has been a lot of abuse of powers of attorney going on in the state of Minnesota. Unfortunately, there's a lot of cases of elder abuse, even here in Olmsted County. I think I see an article almost weekly about people taking advantage of these powers of attorney. So what there was 2.5 years ago was a Vulnerable Adult Commission that came up with a new power of attorney form. So new powers of attorney form after January 1st of 2014 now have 2 more pages. So they went from 3 pages to 5 pages. Your old ones are perfectly valid if they were executed prior to that date. No problem there. Just make sure if you get a new one that it's that 5-page form. And in that form, there's a couple of things that happen that are different. If you want your attorney, in fact, to have the authority to gift to themselves, you not only have to check the box, but you have to enter their name specifically. So if I want my son Bob to have the authority to gift to himself, then you have to put Bob's name in on that list. Now that is also limited, though, what people don't necessarily realize, to the federal gift tax exemption. So for this year, $14,000. So even if Bob can gift to himself, it's only for $14,000 per year. The old form was limited to $10,000. It was not pegged to that rate, so that was a mistake that a lot of people made. $10,000, period. The other part that's different on the form is that the attorney, in fact, has to read a page-long notice telling them what their duties and responsibilities are before they're able to use that attorney, in fact. What that does is it's putting them on notice that says, hey, if you gift this money to yourself, you're going to be in trouble. Because that's some of the problem they were having with people saying, oh, I didn't know that I couldn't use all of Mom's funds to buy myself a house or whatever it was. So that is where the attorney, in fact, the changes that we've seen as a result of some of the exploitation that has gone on. I don't know what the different results have been, but that's where we're at right now. There is also the ability to request accountings on the form. We don't typically put in the requirement of a monthly or annual accounting on the attorney, in fact, but it is important to know, especially when you're acting too as an attorney, in fact, that the principal, the person giving it to you, or anybody really, the court, the county, can ask for an accounting at any point in time. So it's very important as acting as an attorney, in fact, that you keep bank statements, that you keep receipts, that you keep records of everything that's going on, because that person dies 10 years down the road, and they come back and say, okay, what have you done the last 10 years? Where'd the money go? You're going to need to come up with those records. So an accounting is not required, but you always need to be prepared to give that accounting, because you never know. The power of attorney has very broad authority, and I have listed all of the powers here on this page. A lot of them are pretty self-explanatory. These are simple check boxes. The statute is actually 50 pages long, and there's a long explanation of each of these powers on each of the pages. Some of the big ones that I'll highlight is real estate. So if an attorney, in fact, has to sell your home for you, they have the authority to do that if necessary. The other one, obviously big one, is banking and securities. I mean, that's typically where we see it, where people are coming in and doing bill pay. They might have to cash out some of that retirement account or securities. And so that's typically where the powers of attorney are. It's very important to understand what a power of attorney can't do as well. Acting as someone's an attorney, in fact, does not actually give you the authority to act as their attorney. And there's a lot of confusion sometimes in the courts. So you cannot go into the courts and represent that person as their attorney. You can hire an attorney for them, but you cannot actually represent them in court. It also does not give you the right to make healthcare decisions. And part of the new form clarifies that. It's not a change in the law, but a clarification that the N, all other powers, does not mean the authority to make healthcare choices. That's completely separate. So that was some confusion with that in the past. Let's see, the next page here, I think I probably covered most of that. The liability for refusal to act on the bank's behalf if they do not accept, a valid on its face document, and there are damages, they can be sued. We talked about the gift tax exclusion, so I think we've covered all of that. Before we move on to healthcare directives, does anybody have questions?
So, you talked about banks. Do they
Yeah.
have to be incorporated in Minnesota, or if we have something like the Vanguard or somebody else, which is someplace else? How does those power attorneys
Yeah.
with other states?
They are doing business in the state of Minnesota. So they don't have to have a physical location, but like in Vanguard's case, they are obviously on the internet and soliciting and doing business in the state. They have to recognize that. A lot of times they have their own forms to fill out, and you kind of have to go through their own little system to get that, but you can work through it. It might get a little frustrating from time to time, but we make it happen. Yeah.
If you have a trust, does the trust have to be attached to an investment house or insurance policy?
No.
Could you repeat the question?
No, so he asked if you have a trust, it has to be attached to an investment house or an insurance policy. No, I mean, we have trusts that simply own real estate, and then you name a trustee to manage that if you can't any longer, and that might just be, a child, a friend, a family member. So it's not necessarily corporate. You certainly can. There are certainly a long list of corporate trustees, but it's not a requirement. Okay, healthcare directive. As I said, there's healthcare directive in the back. I think that is a newer one that we're using that is a little bit shorter than the old one. If you go to Mayo Clinic or OMC or out on the internet, there's some that are longer that have a lot more questions. Some people really like answering those more detailed questions. What we were finding is that a lot of our clients got stuck and just refused to do it at all because they didn't want it, the questions were a little overwhelming. Some people love those questions, and so we're still attaching those answers as an attachment to that. So really it's a personal choice as to how you want to approach it. Everybody is so very different. Over the last 11.5 years, I've done hundreds of these with people, and they're just, everybody has a different preference as to how they want to approach it. So no right or wrong answer, it's just important to get them done. It's always what I tell people, and important to have that discussion with your healthcare agent about what is it that you do want, because words on a piece of paper, to apply that to a specific situation, I've seen people really struggle with that. So it's really knowing the person and what they want that really helps the individual more than anything, making those decisions at that time. I quickly went over most of these. The healthcare agent has those authorities to make any sort of healthcare decisions. Important to know that the healthcare agent can only act if you're no longer able to make the decision for yourself. A power of attorney can act at any point in time. Now they can't act against if you tell them, don't do that, they can't do it, right? And the power of attorney. Healthcare agent only steps in once it's been determined that you do not have the capacity to make those decisions, or if you can't speak for yourself, if you can't, tell them what you want.
And who makes that decision, or how is that stated?
That can get tricky. It can. Typically, it would be the doctor making a determination that you're no longer able to make that decision. The difficulty they do have with these documents is if somebody is absolutely refusing to recognize the authority of the people that they've named, that's unfortunately sometimes when we have to get the courts involved. So that would be like a guardianship and conservatorship where the court deems a person incapacitated and actually takes away their rights to make that decision. These documents don't take away any rights. So typically they work to handle those situations, but in certain cases we have to go to the court, unfortunately, which we don't ever do unless we absolutely have to. But
Can that
Yeah.
person's capability be an on and off thing?
sure, of course.
Can you repeat the question?
Yes, he asked if that person's capability could be an on and off thing. So you can imagine a situation where somebody's in a vehicle accident and they're unconscious for 2 days, and someone's making the decisions for those 2 days. And then they, regain consciousness and are able to make decisions for themselves. So yes, I mean, it could definitely be an on and off thing. It's not necessarily permanent. We don't see that all that often, but. And then one of the important things of the healthcare directive that we have now is a HIPAA release. You all might be familiar with that annual form that you sign that says you authorize so-and-so to get information. So we're putting that in the healthcare directive to give that person access to your healthcare information. It's always a tricky tricky thing to get around, but we do our best. Organ donation is another important decision that goes on there. If you have it on your driver's license, that is an indication of what your wishes are. You still need someone to sign off on that. So by putting it also on your healthcare directive, you're reinforcing that decision that is going to be signed off on. Also on there, you indicate if you've made any contracts to donate. So a lot of people are part of, say, a brain study at Mayo Clinic, or they're a part of the anatomical bequest program. So we indicate that on the document as well, so everybody knows that those contracts are in place. We just have it in one more spot. Once these forms are done, we then make sure it gets to be a part of your electronic record. So it's really nice at Mayo and OMC, they scan these in, so whether or not you show up at your primary care physician or you show up in the ER or wherever it might be, bam, it's there. 10 years ago, we used to get calls from the emergency room or whatever else. Can you fax them? Can you, whatever it might be. And then it was always kind of a sticky situation. Who is this? Who are we releasing it to? We don't like that. Now, if it's part of your health care, we haven't gotten those calls in years, so we don't have to worry about that anymore. Any questions on the healthcare directive? We will go on to a will. All right. So, what does a will control? That's always the first thing I like to explain to people. A will controls your assets that are in your name alone at the time of death. If you own your home in joint tenancy, if you own a bank account in joint tenancy, those assets would transfer automatically by virtue of those joint tenancy designations. Anything with a beneficiary, whether that is a transfer on death deed on your house, a beneficiary on your life insurance, POD, pay on death, or a transfer on death on brokerage and bank accounts, those will control, and those are not considered probate assets. So real estate in your name alone is always going to be an asset that has to go through probate. If you have a bank account in your name alone and it is in excess of $75,000, it has to go through probate. That's a bit of a change. If anybody has ever used the small estate or affidavit for collection of personal property, as of June 1st, that has increased from $50,000 to $75,000. So we've seen they increased everything by 50% on those numbers. So once we file a probate, that typically means just paperwork back and forth with the court. There's a lot of misconception. It has to be published in the paper for 2 weeks, 2 consecutive weeks. And that's a 4-month claim period for creditors to come and say, hey, you owe us some money here. So we can't close it for that 4-month period. Then we have to do an inventory and final account. All of this is public information, and some people don't like that. A typical probate at the quickest is going to take us 6 months to close, the quickest. A lot of times more like 6 months to a year, especially if we're selling real estate, doing taxes and that kind of thing. 6 months to a year usually to get through probate. On the flip side of that is the revocable trust. So that's kind of a difficult concept to understand, the revocable trust. It's a document that we draft where you are the grantor and the trustee at the time that we draft it. You can think of it as a purse. And you're taking all of your assets and you're putting them into one purse. And any assets in that purse are not a probate asset, but automatically transfer by virtue of that document at the time of your death. So your successor trustee would then administer that. Important things to know, you still have things to deal with like taxes and all that, so there's still going to be some administration to deal with. It's not going to be completely, usually lawyer-free. There's going to be some of that administrative stuff, but it does save you the probate. You don't have that 6 to 8 weeks where you're waiting for the court to appoint somebody. They can go to the bank the next day, get their name on the account, pay the funeral bill, pay medical bills, and it's really a seamless transition. So that is, there's no need then to publish for those. So we don't have to go and put it in the paper. We don't have to do an accounting. We don't have the service requirements. So it's much more private. it gives us an easier ability to do some tax planning. And the trustee just has a little more discretion and ability to do things without that oversight, which may be good or bad depending on the situation. I talked quite a bit about the beneficiary designations already. Half hour goes by really fast. One thing I want to highlight is this transfer on death deed. This has been around since I think about 2008. Prior to that, we were seeing a lot of people go through probate because they own their house and maybe a bank account. Now we don't have to do that. We can do a transfer on death deed, which automatically passes ownership of the real estate to whomever you name upon death without requiring a probate, without requiring a trust. It's very inexpensive to do. It's $46 to record this at the county recorder's office. It costs us about $100 to draft it for you. So really, really easy. It works well if you have adult children who are responsible and get along. And maybe not more than a lot. I mean, if you get to like 6, 7, 8, spouses have to sign off too. It gets to kind of be a lot of people and maybe logistically a little more difficult and probably not your best choice. But it's a great tool for a lot of people to avoid probate, where in the past we've had to go through probate or go to the expense of drafting a trust. So something to be aware of. Okay, quickly kind of running out of time. So these are kind of some examples that we have. So we have Sally Mailwood, who has a revocable living trust and a pour-over will. So these how she has her assets titled. She has a cabin in her name with a Todd to her son, an IRA titled in Sally's name with beneficiary to her daughter, the brokerage account titled in her name, in the name of her trust, requiring distribution to her son and daughter in equal shares, the savings account with, I didn't update that, in excess of $50,000, pretend that says 75. I reused something that was before June, didn't I? And then a life insurance with a beneficiary designation to a deceased spouse with no contingent on there. Her trust gives everything in equal shares to her kids. So, the cabin that is Todd to her son will automatically pass to her son by virtue of that Todd beneficiary. The IRA is automatically going to transfer to her daughter by virtue of that beneficiary designation. And I'm going kind of fast, I apologize. The brokerage account that is titled in the name of the trust will pass via that trust at 50-50 to the two kids. That savings account with in excess of $75,000 is a probate asset. So that will have to go through probate to get to the trust. Oops, we forgot to put that in the trust. The life insurance policy with the deceased spouse and no contingent will likely have to go through probate as well. And I say likely because sometimes you will find that the life insurance policies the contracts will have an automatic designation to children. It's not always, but sometimes. So that one is kind of, it depends on the contract. But a lot of times that would go to the estate as well. So we see some of that stuff all the time where this plan maybe wasn't as cohesive as it could have been. All right, lastly, I'll just talk really briefly about Minnesota estate tax. We still do have an estate tax in Minnesota. It has been gradually increasing over the last few years by $200,000 each year. We were at $1 million. We're now at $1.6 million. In 2017, on January 1st, we'll be at 1.8, and then 2018, it's slated to go to 2 million, and then it's supposed to remain there. The federal exclusion is now up to $5.45 million. So, I'm not worrying about that one too much anymore. The annual exclusion is still $14,000. I haven't heard anything for 2017 if that's going to go up. I'm going to expect it. It hasn't gone up in, I think, 3 years. So I wouldn't be surprised if we saw 15 come 2017, but I thought that last year too. So just real briefly, I put these on the back. We're actually doing some more in-depth estate planning seminars this coming week. So Wednesday from 8:30 to 10:30 at the Kaler Apache, and then the following Wednesday the 19th from 5 to 7 at the Kaler Apache. So I know it says RSVP by the 5th, but we still have a few spots. So these are on the back if anybody's interested in the more detail, because that was kind of quick.